Hi friends, Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. Here's what we're discussing today. The doctor at the heart of our story today is a podiatrist, and up until I reached the ripe old age of 65, I'd never been to one. That's primarily because I could cut my own toenails and my foot health was generally pretty good, but because I'm diabetic, they send me to the podiatrist. So I have a really good podiatrist who also happens to have an Italian name, unlike the gentleman here, though he is very competent. Today we're going to talk about this case. It's Thomas C. Franchini versus Bangor Publishing, Bangor Daily News, all of these different media entities. And as you might guess, when somebody sues media entities, the claim is for defamation. And of course, defamation requires that you plead and prove a false statement of fact that injures somebody's reputation and is not saved by any of the numerous defenses to a claim of defamation. So let's see what the court says about this particular case. The first thing I noted, which is sort of funny, although I guess not really for the judge, it says the three-judge panel included Judge Toruglia, who heard argument in the case, but then he passed away. And it says his death on October 26, 2020 ended his involvement in this case. Well, you'd certainly hope so. I mean, unless they're holding seances or something. Actually, there is an opinion by the Supreme Court that says a Article 3 judge has judicial power so long as he's alive, but after he's dead, he no longer has any judicial power, which only sort of seems to make sense, but apparently you do have to spell things out for people now and then. So Dr. Franchini was the former chief of podiatry of the Department of Veterans Affairs Maine healthcare system at Togus. They call it VA Togus. And he appeals from the district court's grant of joint motions for summary judgment to defendant publishers and reporters. Franchini brought suit against them, alleging that the articles the defendants had written and published, which described malpractice allegations as to his medical treatment of veterans, were libelous and/or defamatory. Now, one of the things that is always true when you have a case of defamation or slander is that truth is a complete defense. So if I were to say that Dr. X is a bad surgeon and he's committed malpractice, that could be a potentially libelous or defamatory statement. The problem with it is if Dr. X has been found to be liable by a jury for medical malpractice, then there is truth in that statement that he has committed malpractice. And so, again, depending on context, you would have a complete defense in truth. And in this particular case, although it isn't discussed, it certainly sounds to me as if there is a lot of truth in the allegations. That's my opinion, and that and $5 will buy you half a cup of coffee at Starbucks. But again, when you go through this opinion with me, I think you'll see there are some really red flags waving here. So the trial court granted summary judgment, which generally means that the facts are undisputed, and based on the facts, there's no need to take this to a jury because there's no fact-finding that needs to be done, and the decision can be made on the basis of the facts. So he says that he should win because there were at least genuine issues of fact as to whether he was a voluntary or involuntary public figure, which is not the case because that's not a decision that's made by a jury. That's a decision that is a legal decision that's made by the judge. And then 2, that he should not have dismissed his second amended complaint for failure to plead actual malice because he doesn't think of himself as a public figure. Now, usually public figures are pretty easy to figure out. Elon Musk is a public figure. Anybody who's a senator or a representative or a congressman, maybe even your mayor, is a public figure. It's very difficult to defame them because they're public figures, they have to show actual malice, which means they not only have to show that you lied about them, but that you knew that you were lying about them and you intended to cause them harm. Though that's kind of a high bar to reach. But in situations like this one, it is possible to make yourself a public figure, as we'll see here in just a moment. The court then goes on to say, we hold on the undisputed facts that the district court correctly found Franchini was a voluntary public figure and that he failed to plead actual malice in his second amended complaint. We affirm the judgment of the district court. For some reason, even though it is completely unrelated to their holding, the First Circuit here essentially goes to the trouble of laying out the history of the Veterans Administration and its legacy of very poor medical care. And it goes through it at great length and I believe somewhat, like I said, unnecessarily. But it does provide a window into why they might have viewed his claims just a little suspect. You know what I mean? So let's take a look at what they did right. The U.S. Department of Veterans Affairs is responsible for administering the laws providing benefits and other services to veterans and the dependents and beneficiaries of veterans. Both before and during Franchini's employment at VA Togus, the VA struggled to provide quality medical care nationally to all veterans who seek it had been the subject of vigorous public debate. And I think the court may be unaware of something there, and that is that people like me who had a health care plan through their employer did not qualify for VA benefits, VA medical benefits. We had to go to a private hospital and pay our own money on our own deductibles rather than go to the VA hospital, even though we were veterans, which is something that has always irritated me. And I am unaware of any veteran dependents who get medical care at a veteran's hospital. They may exist, and if they do, I apologize, but I am not aware of anybody who fits that description. In a footnote, the VA goes through some of the media reports about bad health care at the VA. Federal investigators have documented almost 3,000 medical mistakes and mishaps in less than 2 years at VA hospitals around the country. And Bush promises to help veterans who face health care backlog. And VA healthcare strained by big wave of enrollees. VA health system failing, survey says. And they were waiting 6 months or more for medical care as severely overburdened VA health officials and the health system failed to keep pace with the growing demand. And then the district court noted in its opinion the following articles. Veterans seek service improvements. For veterans, health care on hold, VA staffing shortages. Doctors, veterans voice medical care concerns. For some veterans, the battles go on. Public discussion of the quality of VA medical care nationally and in Maine continued into the next decade in both newspaper articles and congressional hearings. Now, I want to make one thing clear, and that is that I have a good friend who works at a VA medical center in Columbia, Missouri. And my friend is a respiratory therapist. He's been a respiratory therapist since I've known him. And he was a respiratory therapist educator for a long time. Very brilliant guy, very good clinician. And he believes that the quality of medical care at that institution is second to none. And I have no reason to doubt him. There are very good VA medical centers. And it depends a lot on who's administering them, just the way it does at your local community hospital. And that is something that probably ought to be referenced somewhere in here, but to my recollection was not referenced in here. So we know that there is a lot of problems, or there are a lot of problems with VA medical care. And it said that Franchini came on in 2004 to work as a foot and ankle surgeon. He was given the title of Chief of Podiatry, or COP. Franchini served previously in the Navy as a podiatrist. He testified that he'd sought employment at the VA because of the honor and to improve his retirement scenario. 2 other podiatrists who were a lot older than he was practiced with him. There was a podiatry technician. And he alleged that the COP title was a nominal, ceremonial, and non-supervisory title. Evidence bears that out. Even accepting that as true, documents in the record show that on paper, the VA New England Healthcare System's performance plan for a COP for the fiscal years 2006 and 2007 contained performance measures and key competencies. These included maintaining effective relations with the public and media, which results in a positive image of the VA in the network or community. And so, obviously, he didn't actually get that done. According to Franchini, Dr. Sampson, who was his boss, also provided oral instructions to Franchini about his role, and he said his job was to see patients well, make them happy, and play well in the sandbox. Because, as hard as it may be to believe, doctors don't always get along with one another. And in fact, it isn't anybody who's ever worked in a hospital will tell you that sometimes there are cat fights that erupt right in the middle of the operating room. So again, it is a difficult situation if you are a staff member in one of those facilities. And if you're a doctor, generally speaking, you get a lot of support and you have all the help you need to do your job for the most part. In 2009, Franchini was removed from the COP position and became a staff podiatrist. And that was because he was rated as low satisfactory in clinical competency. And the narrative summary on his evaluation said that during this evaluation period, he seemed to lose some of his enthusiasm for the mission of treating veterans. His position was changed from chief of podiatry to staff podiatrist. And the VA, and then in 2009, Dr. Richardson, who was also in the chain of command for him, received a written communication from VA staff, compensation, and pension disability manager raising concerns about Franchini's quality of care. And then in March of 2010, Dr. Sampson and Richardson asked Franchini to voluntarily suspend performance of all surgeries as they performed a focused review of 25 patients. They did that. A focused review of the surgical care provided to you by you was initiated, and we find that medical staff providers that veterans had undergone surgery after minimal evaluation. The chief of surgery reviewed 25 randomly selected medical records and identified significant deficiencies in the clinical care that you provided. You were notified regarding this on March 29th, and you were informed that additional reviews would be performed. Another VA doctor reviewed these deficiencies, similar to those identified by Dr. Sampson. After both reviews were presented to the Professional Standards Board, Franchini was notified of its decision to summarily suspend his privileges, and that aspects of his clinical practice did not appear to meet accepted standards of practice and could potentially constitute an imminent threat to patient welfare. So to be clear here, the other doctors found that this guy wasn't measuring up and that he was potentially harming patients. That ought to be a 5-alarm fire at that particular institution, and apparently they took this pretty seriously. After a third VA doctor reviewed Franchini's record of care and concurred with the other doctors, concluding that the majority of cases he reviewed were below the standard of care, the Professional Standards Board recommended revocation of his clinical privileges and removal from federal service. Franchini was given notice, he contested it, but at the end of the day, he was removed on November 8, 2010, and instead of being removed, he resigned from VA Togus. But the agency finding in his personnel record after he left was that he resigned after receiving written notice of a proposal to separate him for repeated surgical cases in which non-operative alternatives were not employed, resulting in inadequate informed consent for surgery, among other things. The list of errors here is pretty significant. So his letter was dated November 8th, and after that, he entered private practice in the Bronx, New York. So then the Togus director responded in November 19 of 2010 to a letter that Franchini wrote, saying that they were making a review of the concerns raised in his clinical practice, and the results of the review would inform whether Togus would report Franchini to the appropriate state licensing boards. In 2012, the VA sent letters to the state licensing boards of Maine, New York, Rhode Island, Vermont, and Washington, D.C., to inform them that there was substantial evidence that Franchini so significantly failed to meet generally accepted standards of clinical practice so as to raise reasonable concerns for the safety of patients when, during his clinical practice as a podiatrist, he made multiple diagnostic and treatment errors. That in turn caused further congressional inquiry, And then the VA decided that they had to notify the veterans as having potential, probable, or actual harm after a careful review of their medical records. The VA began to notify the patients. They did a consolidated report to Congress. The VA then notified, before 2013, the 25 patients from its initial 2010 review. And of course, all of these people are outside the statute of limitations at that point. And then in April, The Forecaster, a Maine publication, published a story by David Harry about the South Portland veteran fights VA to file damage claim, in which one of Franchini's former patients, Kenneth Myrick, alleged Franchini had provided him with substandard care. And that led to the publication of the other very significant articles by the USA Today, the Bangor publications, and all of that. So 7 patients sued under the Federal Tort Claims Act. Eventually, all of those cases were settled, but all those suits are public records and they were part of congressional proceedings. So it's out there in the public whether Dr. Franchini likes it or not. And he was named in things like exhibits and depositions and a declaration from the VA Director of Risk Management. And Franchini was initially named as a defendant in Carpenter before the United States substituted for him individually. On February 2, the Federal District Court in Maine issued an order in the then pending cases which referenced Franchini by name 64 times. So he learned of that in 2016, and acting pro se, he sent a letter to the district court and asked them to remove or essentially remove the link to his name from that record. And the district court denied the request, saying it's all over the place. You basically can't unring this bell. Even before he filed the declaration in the named cases, Franchini created a blog on June 27, 2016, and this is what does his undoing, called the Foot and Ankle Forum, where he went through all of the things that happened to him at the VA hospital. And of course, none of it was his fault. He was blameless, perfectly pure as the driven snow, and he didn't understand why all of these people were after him. He explained that they were able to resurrect issues after a prolonged period of time. He testified that his sole purpose in creating that blog was to set the record straight. He made a total of 11 blog posts. On October 11, 2017, defendant Gannett published in its newspaper, USA Today, an article co-written by defendant Slack and Michael Sala titled, "VA Conceals Shoddy Care and Health Care Workers' Mistakes." This article detailed how the VA as a whole responded to problems it identified while investigating its medical providers. So it connected also to numerous cases of Franchini's. The USA Today article included comments that Franchini made in an interview with Slack. It stated that in an interview with USA Today, Franchini denied making mistakes. VA placed Franchini on leave after finding problems. His attorney submitted 2 outside reviews saying the VA's findings were not backed up by the medical record. The VA eventually reviewed nearly 600 of his surgeries from his 6 years at Togus. The 56-year-old podiatrist said several doctors were in the operating with him and no concerns were raised at that time. Franchini later testified that he urged Slack to report what he deemed the real story behind the VA's investigation. Indeed, he went further and stated the investigation was a witch hunt motivated by the corruption of Drs. Sampson and Richardson. And then he made statements that, quite frankly, were slanderous, libelous, defamatory of Dr. Sampson and Dr. Richardson. In a declaration filed in opposition to the defendant's motion, Franchini stated when he met with Slack, he told her that Sampson had been directed by his supervisor Richardson to find a way to get rid of me, and that Sampson was later forced to resign because, despite Richardson's urging, he'd been unable to find anything in his review. And added in there that Dr. Sampson may have been concerned that I might be in a position to take over his position. Yeah, right. Anyway, that's what went on in the factual part of the case. The court then comes down and deals with the legal issues. So in September of 2019, the court issued a scheduling order to which both parties objected. Based on an agreement with parties, the court established a bifurcated discovery schedule. Phase 1 discovery was limited to developing the necessary factual background for the court to determine whether Franchini had a public official or limited public official status. Motions for summary judgment could then follow. When the schedule was set, Franchini expressly acknowledged that a summary judgment ruling that he is a public official or limited purpose public official would be dispositive as to the defamation claims and preclude the need for Phase 2 proceedings. So the court extended its deadlines. He filed a second amended complaint, and all the defendants moved again to dismiss or strike the proposed second amended complaint. On April 15th, the district court granted this motion to dismiss. In its order, the court referenced its previous ruling that any attempt by Franchini to amend his claims would be futile and that he still had not alleged actual malice. The case was dismissed, at least in part, on the grounds that Franchini was both a voluntary and an involuntary limited-purpose public figure, holding that there was a public controversy which pre-existed the defamatory statements and that Franchini was a limited-purpose public figure. So the appellate court says we're going to look at this de novo, which means we look at it as if we were the district court. And they say, due in large part to the profound national commitment to the principle that debate on public issues should be uninhibited, robust, and wide open, the First Amendment of the Constitution imposes certain limitations on defamation actions. These include denying recovery to any plaintiff claiming defamation who is deemed to be a public figure, unless the plaintiff provides proof that the alleged defamatory statement was made with actual malice. Although public figure status is inquiry inescapably fact-specific, it is nonetheless a legal question properly resolved by the court, not the jury, regardless of the contestability of the predicate facts. Defendants bear the burden of establishing that he was a public figure, and an individual becomes a general-purpose public figure if he or she achieves pervasive fame, not the case here. Second, an individual becomes a voluntary limited-purpose public figure if he or she voluntarily injects himself or herself into a particular public controversy and thereby becomes a public figure for a limited range of issues. And then that's what they decide he did. The district court correctly concluded that Franchini was a voluntary limited-purpose public figure because the record showed that a public controversy existed and that Franchini voluntarily injected himself into the issues, at the very least, through his blog posts and comments to USA Today. So as often happens in these cases, somebody who thinks they know a lot about the law and defamation and whose pride and ego and professional standing are injured, files a defamation claim and winds up losing in large part due to his own behavior. So that's what I have for you today. It's a doctor's behaving badly instead of a lawyer's behaving badly, but I thought you'd find it interesting. If you have any questions, drop them in the comments down below. Like, share, subscribe, all that stuff. Do me a solid and go out there and do something nice for somebody today, and then come on back here tomorrow, join me at the beach, and we'll talk about some other case. If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.